All right. Well, good afternoon again, everyone. On behalf of Ned Blinick with Third Wave Systems and Blinko, my name is Greg Cummings with TRG Direct. And this is an ongoing presentation of webinars that we've been doing now for the trade for about a year and a half. We continue to look at topics we think are important to the trade, either from a standpoint of legal matters or actual execution and operational issues. And today, we have picked a topic called Changing Legal Environment for Importers, the End of the Age of Innocence. And as I think we were all talking a little bit earlier, I think we struck a chord out there because this has probably gotten the most interest of all the webinars we've done to date. So we're very happy. Looks like we picked a topic everyone's interested in, and we very much look forward to moving forward with our agenda today. So the agenda is going to be fairly straightforward. We're going to start off by going through customs liabilities, and then we're going to talk about importer compliance, and as we always do at the end, we're going to have a discussion, some examples, and of course Q&A. As a matter of course, we are recording this session today, so it will be available to anyone who is either involved in the webinar today or who couldn't make it. Our first speaker is Michael Layden. Many of you are very familiar with Mike. He's a recognized expert in customs compliance for many years. He served on numerous boards, COAC, BACM, AAEI, and is also very well known in the direct filing community for starting the project at Target, and he's been working with TRG Direct now for going on 10 years. So we welcome Mike. Also with us today is Myron Barlow. Myron is currently a principal at Barlow & Company, and Myron began as a U.S. Customs Office international trade litigator where he, yes, represented the government in suits brought against the trade. Since then, however, he has put his own shingle out, and he is out there representing the trade back to the government. So he's got a tremendous amount of experience from both sides of the fence, and we're very happy to have him today. So without further ado, Myron, I'll let you take it away.
Thanks, Greg. I'm going to start off with a brief review of the legal liabilities that are incurred under customs laws. And I thought it would be best to start at the beginning here and to make a quick note for everybody that when you're talking about customs law, you're not talking about, for example, to make a comparison, Food and Drug Law, which is largely derived from the Food, Drug, and Cosmetics Act, which is a pretty recent piece of legislation. Similarly, regulations under the Environmental Protection Agency and other laws that we often deal with, sometimes even associated with imports, are of rather recent vintage. But customs law goes back a long time. It goes back to the colonial period, in fact. And customs was one of the very first agencies that was created by our government in 1789 for the very commonsensical reason that the government needed to collect revenue. And long before there was an income tax, you had import duties. And it's interesting, I'm looking at this last point here about legislatures being good at creating new laws but not so good at removing old ones. I recently received my 5-volume set of 19 U.S. Code annotated, which last year was a 4-volume set, and when I first started it was a 3-volume set. So I think that rings true. We're just getting more, and as you all know, the tariff schedule seems to be getting longer and longer with all the free trade agreement rules. But I'm just going to briefly review some, not all, of the different types of liabilities. First, with criminal liabilities, they're codified in Title 18, and I have written down there a Latin term. It's a legal term, mens rea. What that means is the state of mind. And I have that there because when you're talking about criminal liabilities, they're different from other types in that there's typically written into the statute a requirement that there be some knowing and intentional act. So one of the criminal statutes, that's one of the things that is the first item Customs grabs for in its bag of tricks when it's going after someone for criminal liabilities, would be 18 U.S.C. 545, which is technically the smuggling statute, and it's defined very broadly as an import contrary to law, which, as you can imagine, can cover a number of things. Although it's qualified again because it's a criminal liability as being applicable to someone with intent to defraud. The penalty is a fine, 20 years of imprisonment, and forfeiture can be involved as well. And who can be the subject of a Section 545 action? Well, it could be the person who's making the importation or attempting the importation, but more broadly, more generally, it can cover one who receives, conceals, buys, sells, or facilitates the transportation of such goods. Another Title 18 criminal statute that we see frequently in customs cases would be 1001, which covers false statements. This is, as it suggests, simply a provision concerning the knowing concealment of a material fact or making a false statement. The penalty there is a fine plus 5 years imprisonment. Next slide, please. Lastly, I have listed here Section 541, which covers, yes, false classifications, which is the knowing payment of less than the amount legally due or a misrepresentation of the value or weight of the imported merchandise. And the penalty involved here is a fine plus a 2 years of imprisonment. One of the things that we've noticed really just in the last 3 to 5 years, it's intensified, is what we see as an increasing trend to criminalize customs errors. Cases where in the past a mistake has engendered a civil penalty action, for example, or some other form of action, is more frequently these days being the subject of a criminal action by customs against the wrongdoers. And I think there's a number of reasons for this. I have some of them listed here on this slide. Of course, as we've seen, as we've reviewed the 3 criminal statutes above, there's often a fine or penalty, monetary penalty involved, so that's a revenue-generating statute for the government. Secondly, bringing the criminal claim can help to incentivize the settling of civil claims. So we've seen that from time to time, where the client may have a pretty good defense or argument on a civil penalty action brought against them, and customs ups the ante with a alleged criminal violation, and that will incentivize the settling of the civil issue to avoid any implication of criminal wrongdoing. Lastly, we note here on this slide, and I think this is an important thing to keep in mind, and it really goes to what we're talking about today, and that is that we have an agency that was the U.S. Customs Service at the Treasury Department, having been transferred after the 9/11 events to being within the Department of Homeland Security, which is a entity that was created to be a single point to help fight the war on terrorism. And this is important to note because it really has to do with the attitude of some of the people at Customs that you may be dealing with. And it's important, of course, to look at the titles of the people you're dealing with. We had a case not too long ago, dealt with a rather, I thought, straightforward intellectual property rights alleged violation. We were able to straighten it out and clear things up. It was not a violation. But I was actually, the person sitting across the desk from me in that case was a Department of Homeland Security agent whose card read non-proliferation investigations. So we had someone involved in tracking down weapons of mass destruction. So we've seen this, intensification to the criminal side, and that's been troubling. Now for civil liabilities, Customs' favorite statute here is Section 1592, which deals with fraud, gross negligence, and negligence, and I just briefly summarize it here. What we're talking about under Section 1592 would be an importation using a material false statement or omission, regardless of revenue impact. And there's 2 important things there I'd like you to take note of. One is that it doesn't have to be a false statement. It could be an omission of required information. And secondly, that you can have a 1592 violation even if there's no revenue impact. So if you make a mistake, it didn't cost an underpayment of duties, it still can be a 1592 violation. In fact, there was a famous case not too many years ago where an importer had actually overvalued imported merchandise, had overpaid customs duties, and customs went after them for 592 penalties for misvaluation, even though it resulted in an overpayment of duties. Penalty under 1592, there's a wide range of penalties there depending upon the degree of culpability. It ranges from 2 times the loss of revenue to as much as the domestic value of the imported merchandise, which can be a big number because, again, we're not talking about entered or imported value, we're talking about the downstream domestic value. Who can be liable for 1592 penalties? The importer of record can be liable, but also any person aiding or abetting. And we'll see a little bit more about that in a couple more slides. One of the most common defenses against the 592 claim would be alleging that reasonable care was exercised, and frequently in 592 cases you have a mitigation process to petition for relief where you apply aggravating and mitigating factors. Next slide, please. A little bit more about the reasonable care standard, because that's an important part of what we're talking about today. It's created by statute, by Section 1484, and it can provide an affirmative defense against certain customs liabilities, as we suggested with Section 1592. And it essentially states that the importer of record shall, in person or by authorized agent, use reasonable care when declaring imported merchandise to customs and in determining whether all applicable legal requirements have been satisfied. A couple of interesting things to note here. Shall, in person or by authorized agent. That's a reference to your customs broker. In other words, under the statute providing for the reasonable care standard, you are obligated as the importer to oversee and monitor your broker, your authorized agent, and are liable under the statute for their mistakes. Next slide, please. A little more on the reasonable care. Evidence of reasonable care would include having a knowledgeable, empowered person handling the customs business at the company. Knowledgeable and empowered being keywords there. You just ask some poor guy in the logistics department who has no customs experience and say you're responsible, and you don't give them any training and any access to change problems that he sees. That's not a satisfying requirement. With access to required information, with access to customs resources. Written internal procedures can be evidence of reasonable care, by the way, and this goes to the Ford case of a couple of years ago. If you have written customs compliance procedures that you do not follow, it's not evidence of reasonable care. To the contrary, it is in fact evidence that you have in fact documented your wrongdoing, haven't you? Because you put together a manual saying here are our requirements, and then you are giving notice that you have knowledge of these requirements, and then you fail to follow them. So when it comes to internal procedures, it's great to have them and to follow them, especially if they're written, but do follow them once you generate them. Lastly, I want to make a particular note of this last point because it confuses people a lot, and that is this. Under the reasonable care standard, evidence of reasonable care includes getting guidance from a customs expert. It can be a customs lawyer, a customs broker, a consultant, some expert. And really what that's talking about is getting a written opinion on a narrow issue or subject where a review of the applicable legal precedent is provided and a conclusion is reached. I mention this because a lot of times I hear from importers, well, under the reasonable care standard, I can rely upon an outside expert like a broker, and I've therefore found some essentially a loophole here where I can outsource my liabilities and responsibilities under customs law to the broker because they're the outside expert, and I've engaged them to do this work. If they make a mistake, it's their problem, their fault, not mine. That's not what the reliance upon an outside expert aspect of reasonable care goes to. Next slide, please. So to what extent can an importer be liable for the acts of its broker? I want to talk about two things here. The first is a common law concept, which provides that under agency law, the importer of record remains liable for the mistakes of its brokers that are acting under the authority granted by a power of attorney. That's right. When you engage a broker, you sign a power of attorney. That power of attorney sets forth the scope of the customs business that broker is authorized to conduct on your behalf. if the broker makes a mistake within the described activities or scope of that power of attorney, it's the importer that is the principal that is on the hook for those mistakes, not just the broker. That's important to know. Also, as we were talking about earlier under Section 1484 in the Reasonable Care Standard, you may recall that the importer of record is responsible for providing the broker all required and accurate information for making a declaration and for overseeing and reviewing the broker's declarations for correctness. The broker is only as good as the information you give the broker, if you are negligent in that regard, it will come back to roost back with you. All right, let's talk about the Trek leather case. This is a case that a lot of people have been talking about. By the way, I just recently read it was appealed to the Supreme Court. So while this is a Court of Appeals for Federal Circuit case, the appeal is pending on some of the issues. It'll be interesting to see if the Supreme Court actually accepts or adheres this case. To the extent it does, I don't know how much can be done because so much of the decision was based upon the language of the statute. But let's review the case as it stands. This is a case that upheld customs authority to impose penalties on company personnel individually for errors made in the company's entries as declared to customs. So it was individual company executives, in this case the president, who were found liable for customs mistakes. And what happened in this case, the facts in this case were that the supplier provided invoices to the importer. The importer passed them along to the broker because the invoices correctly stated the price paid and the merchandise covered. And the broker used those invoices to make entry. But those invoices did not include the value of an assist. The imported product was men's suits, as I recall, and the assist was in the form of material or fabric being provided to the foreign supplier. And as some of you may know, if you're using the transaction value method, you have to include the value of the assist in the value reported to customs. A common mistake, quite honestly. But the customs decided to go after the company and the company president individually, and the Court of Appeals for Federal Circuit upheld the determination that indeed under customs law the executive, in this case the president, could be found personally liable for the $45,000 in underpaid duties as well as the over $500,000 in associated penalties. Next slide, please. A couple of things I'd like you to take away from the Trek case I've noted here on this slide. One is that the government doesn't have to pierce the corporate veil to seek personal liability against company personnel. And again, if you're not familiar with that legal term, pierce the corporate veil, one of the reasons people create companies is so that if a mistake is made, it's the company that's liable, not the individual officers or executives. And if you want to go after individuals at a company, you have to, quote, pierce the corporate veil, which requires a lot of jumping through a lot of legal hoops. It's difficult to do. But under customs law, the court found, under the language of the statutes, you don't have to pierce the corporate veil to go after individuals. Additionally, to the second point on this slide, the government does not have to prove that false information was intentionally provided to customs for there to be a personal liability. A negligent omission of required information is adequate to establish personal liability, and we saw that in this case. Simply the passing along of an invoice that did not, from the supplier, that did not include the material assist. Again, a common occurrence, which is what's so shocking about this case. Lastly, the government does not have to prove that the individual performed the filing of an entry with customs. That was one of the defenses they raised on behalf of the president in this case. Hey, it's not like the president was filing entries with customs. How can the president be liable? But the court held that the government need only show negligent conduct concerning introduction of merchandise into the commerce of the U.S. Very broad. All right, next slide, please. I just wanted to make a point here that there are a number of provisions, including Section 1595, that authorize customs to go against not just the importer and other parties, but against the goods themselves, against the vessels, be it an ocean-going freighter or an airliner, bonds, liquidated damages against bonds. And this is important to know because it's kind of a multiplier. I haven't seen it come up often, but I have seen it come into great effect from time to time in that customs will go against the importer and also throw against the carrier an additional claim based upon the underlying violation. And you're talking about going against the carrier, you're talking about going against the entire value, a seizure forfeiture action against the entire value of the vessel. And if you look carefully at your contract with your carriers, you'll see that you're the one ultimately responsible for errors that you make that incur those kinds of liabilities. So it's not something you see often, but it's something you keep in the back of your mind. You don't want to be the one person who gets caught flat-footed on that. Next slide, please. I want to talk a little bit about the role of brokers in customs enforcement cases. First, as you all probably know, brokers have a license issued to them by customs, and that is essentially how they operate their business. That's the means of their livelihood, and the brokers owe a legal obligation to customs. They have to be honest with customs. There's a couple of specifics listed in the regulations and statutes. So as a result, it's probably not. As a result of that, it's probably not too surprising to many that many customs enforcement actions are actually initiated by brokers. They see something that doesn't look right, they tell customs. Even if a broker doesn't initiate enforcement action, it is quite common for them to cooperate. We had a case recently dealing. We used that e-allegation process to start a customs enforcement action against some competing imports that were wrongly imported. And they acted very quickly, just as an aside, customs did. But I was surprised. One of the first things, maybe I shouldn't have been, one of the first things that the customs officers did was to go to the broker and say, well, we're now investigating these alleged wrongdoings. What have you got on this company? And I was expecting the broker to maybe drag their feet a little and say, well, we can give you this, but we can't give you that. But it was all open books. They were happy to share everything they had and more. So because, you're one of many companies that brokers doing customs business for, they can't jeopardize that license or their relationship with customs. Lastly, that last point is an important one. Later when we get into discussion with Mike, I'm looking forward to that discussion. It'll be interesting. We have some examples. I've seen some cases recently, even with criminal liabilities, where when customs is going after the broker for its wrongdoing, they implicate the importer, even if they do so wrongly, and it causes significant difficulties for the importer, as you can imagine. Next slide. And I think that's you, Mike.
Yeah, it is. Okay, thanks, Myron, for that presentation. And for those of you that don't know me, I am Mike Layden. I see a number of familiar faces on the registration list, but I've been in this industry quite a while. I'm going to go ahead and date myself here. One of my first life's lessons as a broker, and as you see, circa 1973 is when I first got into the business and cut my teeth as a customs broker. One of the very first lessons I got was from a customs inspector based in Minneapolis, Minnesota. And I was down there clearing a shipment and said something to him about, well, what about the importer's rights? And he stopped dead in his tracks and literally stood there and said, never, ever forget the words I'm about to tell you, as he was wagging his finger in my face. He said, young man, importing into this country is a privilege, not a right. Importers have no rights. There's nothing in the Constitution that guarantees a company or a person the right to import. It's a privilege. And as such, like any privilege, if it's abused, we'll take it away from them. Now, that's an extreme case where you're going to actually get your ID privileges or right to make entry revoked. But that's how customs approaches this. Importing is very much viewed by them as a privilege. But having, again, a 30-year plus tenure in the business, I learned that it's not exactly true. Importers do have some rights. Certainly you have the right, if there's an entry error, to do protests or post-entry amendments. You actually have the right to go down and visit with customs and discuss your businesses with them, as well as a variety of other rights that Myron could expand on. But one of the things that some importers have trouble getting their head around is you also have the right to import or conduct your own entry processes, meaning the right to self-file your entries. And importers have always had those rights. And some are under the mistaken notion that in order to file an entry for my company, we need a license. That's not the case. A company that's filing on its own behalf with its own employees needs no license whatsoever. Now, I'm the first one to admit that it helps if you have a license or two in the office, certainly, and you want knowledgeable people doing it. But the bottom line is a company needs no special license to file their own entries. The irony here, though, is that you would need a license if your company was going to file an entry for a wholly owned subsidiary or another division, because that's essentially conducting customs business for another entity, and despite the fact that you own them wholly, it's one of those idiosyncrasies or quirks in the customs law. Your entity that you are employed by is prevented from conducting customs business on behalf of any other entity, even if they're in your family of companies. So we're in, times have changed, and we're in an age of DIY, do it yourself. Our Wi-Fi enabled digital world has really transformed everything we do. Today, most of us do our banking online. We do our own personal taxes, which is just coming up online. Some people buy homes or automobiles. Just about everything we do is online. And as a result, certainly of the MOD Act changes in 1993 and now our digitized environment, most importers today are, as the MOD Act requires, taking the responsibility to classify their own goods and determine value and origin and if things qualify for free trade agreements, and then transmitting that data in some form or another, either by paper or today electronically, to their brokers. The same data set that you're transmitting to your broker can actually be leveraged directly into an ABI system. And I think Greg and Ned would concur with that, and we'll have some comments about that later. Knowledge is power, and I'm a fervent believer that no one knows more about the product you're importing than your own flesh and blood. And along those same lines, no one knows more about the specifics of your unique operation. Myron was talking earlier about Trek Leather and how they missed some assists. Well, certainly if you're immersed in the process of filing entries and preparing them for customs, you're going to have a much higher state of awareness about the need to make that extra declaration of an assist or a commission or non-dutiable charges than sometimes a broker would have. And I'm a fervent believer, too, that no one, and this isn't to besmirch or belittle the brokers. We have many on the line today. They wanted to hear what we're going to say. No one, though, will take greater care in the processing of that entry than your own flesh and blood. I'm convinced of it. I've seen it. I've experienced it, and we'll get into some examples of that in a little bit. First thing a lot of importers say, though, is, "Oh, wait, though, we don't have the resources to file entries." Well, first and foremost, if you're not auditing your broker's work product, you should be. And I can't tell you how many importers I walk into because it's a mind-numbing exercise or something that typically falls off the radar. I can't tell you how many importers I visit with that aren't doing that. But take it from me, if you're not and you're one of those, you should be. And at least a nominal percentage, 10, 15, perhaps as much as 20%. And then like anything, if you find errors, you begin to expand that sample size. But the bottom line is you're responsible for the data integrity and the accuracy of that entry. And so if you're not looking at them, you're not, in my mind, and I think Myron's opinion too, you're not really conducting your business under the guise of reasonable care. So if you are one of those good importers that are double checking some of the work or all of it. And I know some importers, I was visiting with one earlier this week in Ohio, that audits 100% of every single file. If you have people like that, you can repurpose most of those audit assets to work on the entry side of the equation. Why? Because there's still, in my mind, a necessity to audit a very nominal sample of your own work product, but certainly there isn't a need to audit 100% of it, especially if it's your own trained people that are processing those entries. And of course, if it's automated, it essentially becomes a data dump. So as long as that data integrity is stellar, the data accuracy populates the entry. It's double checked by a human being against a live set of documents that you've received from the vendor, and everything is pre-populated. Now, one of the things that made me nervous in a past life when we did a process like this was they talked about a hands-free entry. Look, Ma, no hands. That kind of statement makes me very nervous. And as we went forward in setting up our own direct filing operation, I insisted that we get away from using that terminology and calling it a hands-free entry. But like any system also, once you begin to use it, your productivity increases with familiarity, and I think you'd really be surprised at the productivity you'll get out of using this kind of a system. The other aspect, too, is if you do consider direct filing, one of the big benefits is you save some money along the way, and your direct filing operation could also then be funded by those savings. So more compelling reasons. You get greater visibility. You're more in touch with your vendors and suppliers. You're aware of which vendors are habitually sending you late documents. You're aware of which suppliers are continually making documentation errors, and you can get on top of it much quicker. In my past experience with an importer, I found that vendors were making errors and our broker wasn't telling us about them. They were simply pencil whipping the errors by correcting it and resubmitting to customs, but we weren't getting feedback from that broker about the errors. And then sure enough, what happens? The guy that was pencil whipping all the errors and on the lookout for them goes out on ill or on vacation. Someone else sits in his spot. They don't catch that error, and now you've got a mistake going to customs. In a lot of cases, you can take 1, 2. I've seen, was with one importer where we actually took 3 days out of our supply chain by going to direct filing. Why? Because brokers are typically torn because they're handling multiple clients and thousands of shipments sometimes, and they're processing those in date order. So if your documents arrive at a broker early, you're going to be put in that work queue until the ETA is much closer before they file that entry. In the instance of ocean shipment, you can actually pre-file the documents up to 5 days in advance before that vessel arrives at the first port of arrival. That's not the case, by the way, with an IT shipment or an in-bond, but you can if you're going to discharge and clear at the first port. And what happens is you get on top of it much quicker. You're incentivized to file those documents as soon as you get them. And this is the biggest one, vastly improved compliance. And I'm going to talk more about this in the 2 examples I use in just a minute. But I've seen and heard from lots of people that have gone to this type of filing process that their compliance rate has shot through the roof. And I know of one Fortune 200 company whose compliance rate today is 100% on the entries that they file themselves. Not 99.9. They're very proud of the fact that literally they've got reports from ACE that note their compliance rate is at 100%. And you have significantly improved control over your entire import process, which is, in fact, taking the reasonable care statute to an extreme. You get much better control over it. You're more involved. And in some cases where there's an issue with a shipment, yeah, you're the one that actually might have to get on the phone and call customs. But instead of waiting on a third party to do that for you, you're not only establishing that relationship with customs, but you're hearing it with your own ears, and you're doing it much more efficiently and quickly than perhaps a third party might. And then ownership, last but not least. As Myron's already alluded to, an importer cannot abdicate, assign, or otherwise vacate the liability that comes with being an importer. So one of the most dangerous phrases in the English language, we've always done it this way. And yeah, it's a very powerful statement when you hear someone say that. And we're in a world of change now, so there's no reason not to consider viable alternatives that our new era has provided us with. So I said I'd date myself, and I will. When I cut my teeth in the business, I was with a company called Fritz, and they were at their time one of the largest customs brokers in the U.S. We had about 40 officers when I was with the company. This is a picture of the 1982 managers meeting. And yes, I'm in that crowd. For those that don't know me, there I am in all my glory with all my facial hair. But again, this was a very valuable experience for me, my time with a broker. And when I would go out to market our services to other importers, one of the things I would always say is, why don't you give me a couple of invoices from your current broker and let me take a look at those. And within minutes, usually, and I've found very few that I couldn't because I have an eye for those kinds of things, usually within a couple of minutes, I could start going through their documentation and start pointing out errors to them. And again, back in the 80s, they were all over the board, everything from classification errors to missing non-dutiable charges to not recognizing if it's a related or not related transaction, country of origin issues, quantity issues, you name it. And of course, by selling our services as a broker, when I would point out the errors to a prospective client, that usually got our foot in the door and allowed us to at least be considered to win their business. But it shocked me time and time again how many importers I'd visit who would let me look at their documentation, and then I'd start finding all kinds of reasons that they shouldn't. They should either take on that audit themselves, or they shouldn't be working with that particular broker. Then in the mid-'80s, like a lot of brokers do, I wondered and aspired to be on the shipper side of the equation. And that opportunity came with a company called Fingerhut. In their day, they were a catalog merchandising company handling everything from jewelry to sporting goods, electronics, foodstuffs, apparel. And that was also my first experience in direct filing. My boss at that time said, hey, you're a licensed broker. How come we can't file our own entries? And that's when I really began investigating, is it feasible? And sure enough, I found not only could we, but there were already a group of companies in the Minneapolis area that were already and had been for many years filing their own entries. In fact, way back then, Mattel Toys was one of the leaders on the cutting edge of doing it yourself. And we did some benchmarking with Mattel as we got ready to set up our program. In that time, we were doing about 6,000 entries a year. And we actually brought the entire process in-house, and I saw readily, again, how we not only saved money, but our compliance rate with customs, we went through the roof. We received less rejects and so forth. Then in the mid-1990s, I had the opportunity of a lifetime, and that was to really go to the second largest U.S. importer and run their entire import program. I mentioned earlier that Fingerhut was a medium-sized importer doing about 6,000 entries a year. Target, on the other hand, does 300,000 entries a year. and those come from 84 different countries around the world. So it's a massive and unwieldy supply chain. When I first got to the company, we were in the midst of a CAT audit, which is the precursor for a focused assessment. CAT stood for Compliance Assessment Team. The auditors had been in the building for 2 years and 7 months, and I'm not embarrassed to tell you now that Target had almost failed every module of that CAT audit. So we had lots of compliance opportunities, and I spent the first many years at Target actually getting our compliance house in order, getting import document manuals set up, setting up classification processes, and so forth. About midway through my time at Target, my boss sat down with me and said, "Tell me about this direct filing thing you did at Fingerhut." And I looked at him and said, "Oh, Mick, you don't know that. Yeah, it's possible, but you know, given our size, I'd say it's unlikely that we could set up or establish a program as such." He said, "No, tell me about it. What did you learn through it?" And I started going through some of the things about compliance and savings and visibility and in touch with the vendors. And he said, "Let's do it." And just like that, really, we did a lot more research, of course, and a lot more organization and getting ready to roll it out. But he was convinced that it was the right thing for the company to do. So back in, it was really 2000 and 2001 that we started standing up that program at Target. And one of the very first things I did was met with our current customs brokers, told them what we were about to do, and that this wasn't a black mark against them. We wanted their partnership and assistance through this process, and they pledged it, and we actually got it. But ultimately, we took in-house about 90, I think today they're doing about 97% of all their customs entries themselves. So with that, and I think, Ned, if there's questions out there, I don't have visibility to them, but I think we're going to get Myron back on the line here, and then we'll be happy to take any questions from the audience that you may have.
Hey, Mike,
yeah.
Before we start taking questions, and Ned, you can start to put some of those in the queue if you'd like, but I thought it would be helpful to have kind of an open discussion with you and Myron on what I think is kind of the hot topics today, which is some of the things that are happening in the legal environment. And things, you know, I think what our audience is looking for is some further examples and discussions on individual situations where importers have found themselves running very awry of the law. You know, and Mike, I know you've got a couple of examples of, you know, badges and guns drawn coming in and picking the CEOs, you know, off the floor. And Myron, I know you've got some examples too of some things that you've been working on case-wise. If you could just have, you know, an open discussion here for a couple of minutes on some of those examples to further educate the audience on kind of what's happening real world out there. I think that'd be a very helpful place to start.
Sure, Greg. It's Myron. I can start the discussion on that. And just so everyone knows, that's essentially where the idea for this webinar came from. Mike, Greg, and Ned and I were talking, and we kind of saw, well, we did see very similar trends in terms of what's been happening in recent years. And it was interesting for me because I see it from a legal perspective. If something gets to the point that it's a significant legal matter, we get involved, and to hear the perspectives of others, brokers, consultants, service providers, you know, is to me very interesting, the different angles that we're kind of all seeing the same trends, and it's really something that's been intensifying, in my opinion, from what I've seen, really the last 3, maybe the last 5 years. And it goes to what we were saying earlier. The Customs has in its bag of tools a number of legal provisions, some going back many years that are very draconian, very strict, and we saw, well, I'll give you one example. I will change the facts a little and keep the names out to protect the innocents, because there were innocent people involved in this. But I'll keep the essential facts the same. We had a case not too long ago, and it concerned some workers at a customs brokerage, and they were physically located off-site at a foreign trade zone area. So they were away from the main office, and they weren't being effectively monitored by the brokerage or by the importer, for that matter. And they implemented a scheme to defraud customs of revenue. Essentially, this is what they did. They would receive, it's essentially a duplicate invoicing scheme. They would receive the correct invoice from the importer with the correct description of the merchandise, the full value and quantity, and would receive also from the importer the full duty payment that was owed to customs. But then what they would do is they would make a fake invoice showing a lesser value or volume of goods, or maybe a different classification or description, and they would use that fake invoice to make an entry with customs under which they paid only half the duties owed. The other half they put in their pocket. They kept to themselves. That was their scheme. But what was interesting here was that they then, after they did that, would put together a fake entry package to send back to the importer of record. So the importer of record, was looking at the records that they were getting from the broker. Not all do, but even if they did that, if they just looked at the records, their records show that the entries were being correctly made. When they were eventually caught, the first thing they did when customs caught up with them was essentially to lie to the customs investigators to implicate the importer, saying that the importer was in on the scheme. And they did that because they wanted to offer their testimony as a means to negotiate a lesser jail time. Unfortunately, Customs acted upon those allegations. They brought criminal charges against 3 of the executives at the importing company. You can imagine the fallout from this was terrible. The division was essentially brought the division's operations to a standstill for quite some time. There was significant expense and effort required to resolve the problem. So it just goes. I think it exemplifies the extent to which you really need to be aware of your responsibilities and understand that those responsibilities remain with you. You can't outsource this. And actually, interestingly, I don't want to say the funny part, but perhaps the strangest part of the story was even after the issues were resolved and everything was settled, the last thing the Customs said to the importer was, by the way, you still have to pay us plus interest for the duties you gave to your broker that they kept and didn't pay to us, Customs. You're still liable for that. I can't remember, Mike. I'm pretty sure it's in the Customs regulations. Maybe it's in the power of attorneys that importers signed. That's in the format power of attorney that brokers give to importers.
Absolutely.
That's
exactly
law that the importer is responsible for those duties, even if they give it to the broker, if the broker holds on to it.
Yeah.
And Myron, would in this case a company having their own ACH and direct payment to customs have mitigated that?
I hate to jump on Myron. You bet. That's the only way to go in today's day and age, in my mind, is pay your duties to the entity or the government agency that wants it and needs it, and that's direct to customs through an ACH program. And if you're not currently paying ACH, it's very easy to establish, very safe. I hate to say those words in this day and age of cyber hacks and crime, but it is. It's been in place at least the last 10, maybe 15 years or longer, and I've not heard of any instances of any hacks or untoward or unwanted attacks on your bank account. And there are ways, too, to set it up where it's essentially foolproof. You can use in ACH either the debit or the credit option. You can also, as a member with ACH, then graduate to the periodic monthly statement where you pay your duties once a month. That's a very favorable thing to do because you get a 30 to 45-day one-time hit, positive hit to cash flow. And if the reason those statements were came about and were required to be put on a power of attorney was a direct result of a number of broker bankruptcies over the years. And what would happen is an importer would advance the duties or pay the duties to the broker in advance, and then the broker files a bankruptcy action. Those duties are gone. And customs would either come to the importer of record or their surety company looking to get the money back. And many importers got caught by that and had to pay the duty again. So many years ago, Customs made it a part of the regulations and mandated that every broker that hands out a power of attorney to an importer to be signed, it must include a statement warning you that if you pay that broker and anything happens or he doesn't pay the government, you're going to owe the government again, and they're not going to go to the broker. They're coming to you and your surety bond.
Yeah,
sorry, Greg, to be so long-winded, but
no, it's just kind of,
about that.
It's kind of an easy way to avoid what has essentially about put that company out of business.
Right.
Now, we've got some questions coming up, but Mike, just real quick, go through the CEO getting taken away in cuffs.
Yeah, well, that happened in the Twin Cities to a good Twin Cities-based company that got a little careless. And actually, it goes back to what I was saying about it does help. You need to have knowledgeable people in your operation that may not be licensed by Customs, but certainly have been in the industry for quite a while. They need to have a base of knowledge. And this was an instance where the company had promoted someone because they've been a tried and true employee for many years, and she kept getting promotions. And one day they promoted her into the trade compliance area, of which she knew nothing about. Now, you know, that's really to the company's fault and goes to the standard of taking reasonable care. But that individual then subsequently gave out some internal information that wasn't right, and it related to duty drawback. And one thing led to another. In fact, I dug out the article. This happened again several years ago. But there was an actual raid, and they showed up on a Friday morning with 50 federal agents from. They had borrowed ATF and IRS agents so they could have enough manpower because it's a monstrous company. They pulled up on both sides of the building in white Ford Econoline vans. One guy got out, went into the guard's kiosk in the atrium, identified himself as Customs, and told the guard to move away from the desk, took control of the entire kiosk, and started shutting down the elevators, the banks of elevators in that building. And when he gave the green light, 50 federal agents poured out of those vans on both sides of the building, entered it. They went to the 9th floor where the import group was and came off the elevators with a megaphone requesting everyone to stand at their desk with their hands in the air and line up along a wall. While that was going on, 2 more federal agents went to the 32nd floor and grabbed the general counsel and the chairman of the board by the nape of the neck and brought them down to the 9th floor. And by the time they got there, Customs had that entire area roped off in crime scene tape. And they spent the next 3 days, Friday, Saturday, and Sunday, in that building, literally taking it from pillar to post. So that's a frightening experience that nobody wants to endure.
No, nobody in a company wants to see the CEO get taken away. Otherwise, they'll be cleaning their own desk out. So,
right.
Well, Ned, I know we've got some questions, so I'm going to let you throw those out to the panel.
Hey, Ned, remember that one question we got back when you first put the notice out?
Yeah.
That was a really good one. Let's start with that.
Sure.
Yeah, do it.
The question was, the question was asked by one of the participants or one of the registrants who wanted to know, or who had experience as a customs broker, and his experience was that many importers certainly are very unaware of their responsibilities in bringing a product into the United States. And he is now on the importing side, but it was sort of a question as to what or how can an importer, I guess, inform themselves more completely about their responsibilities and their liability in managing an import program.
Okay.
And I thought that was a great question, because he also raised, the issue of having someone else be the importer of record. Am I remembering that correctly?
That's correct.
And it's an interesting strategy, and I think a lot of people have a similar way of thinking. There are some very large companies, I won't mention them, that follow that theory. We're going to buy a lot from you, so you're going to be the importer of record. You're going to supply us DDP, deliver duty paid, and you take care of the customs responsibilities.
Right.
And there's a couple of things to keep in mind here from a legal perspective. First, if you're going to make another entity the importer of record, you need to make sure that entity qualifies to be an importer of record. And the standard there is relatively general. You have to show a financial interest in the transaction, the import transaction. But if you look at some of the rulings and you get into the details, you need to make sure that you do have a qualifying financial interest. So not just anyone can be the importer of record. And secondly, as earlier as we went through the language of some of the statutes, each statute's a little different. There's a lot of statutes out there. We can't go through all of them in the time given to us. But you may recall that a number of liabilities were not limited just to the importer of record. If you're someone who aids and abets or facilitates in a customs error, that liability still can come home to your company. So I think that certainly is a strategy that can be effective to try to make someone else importer of record if you've got the business leverage to pull that off. But that doesn't mean you're going to completely wipe your hands of problems. And we had a case dealing with something quite similar recently, and it had to do with the customer here in the U.S. getting the supplier to become the importer of record, but the customer didn't stop there. They then continue to be active in terms of deciding classification positions to be taken on the entries, even going so far as to communicate directly with the broker handling the other company's import transactions, and telling that broker how that other company's entries should be declared. So this is, it's a strategy that you can pursue, but don't think it's going to. Remember, you still have responsibilities and obligations.
Right, and I would add to that, Myron, for those importers that are out there, and I see them all the time. A lot of times I'm presenting somewhere and they say, Mr. Layden, I get it. But when I get back to work, my boss just, oh, yeah, poo-poos me, no, we can't do that, not enough research. If you're having difficulty getting the attention of senior management, I have a pretty good way. Now, I understand every company has different cultures and different ways about approachability and so forth. But one of the examples I give people all the time is, no matter where you report within that company, whether you're part of the law group or logistics or operations or merchandising or inventory or finance, there's two people in that company beside your boss that you want to get as close to as possible. And the first one is the CFO. To the greatest extent that you can have a one-on-one meeting with him, I'd take that opportunity, or maybe one of his designees. But when you sit down and start drawing out tax analogies, because a CFO, his job is to guard the purse strings of the company. And if you enlighten him and he wakes up and realizes the amount of penalty that the company could be subject to under the customs laws, it ought to get his attention. And using the tax analogy, I'd go to a CFO and say, I bet we spare no expense in hiring accountants to file our taxes every year. And absolutely, we get the best of the best. Well, did you know that we're filing 300,000 tax returns? And it's not every year, it's daily. And he looked at me with bulging eyes. What do you mean? And I said, well, every customs entry can be viewed as a tax return. It's a declaration and representation of the federal government that if it's wrong, you're subject to penalty. Wow, that was an eye-opener for him. So you get his support, and of course the CFO usually has the ear of the president or the CEO, and it paves the way for some things. The next individual, of course, if your company has one, is the general counsel. Why? Because they're the legal experts, and they may not know anything about customs law, but you encourage them to study it a little bit. One of the most powerful things I've heard from an attorney in the industry who was formerly with Lucent Technologies was she said, as I came out of law school and got my job here at Lucent, I went to the law department and they assigned me trade and trade compliance. And she said, I didn't know anything at all about it. So really to get my arms and head around it, I sat down and read the federal sentencing guidelines for trade law violations. That got my attention. So if you do have a general counsel, it's important that you sit with them and or her and talk about customs and not be the boogeyman, of course, or try to scare them. That tactic usually doesn't work, but at least let them know that the company is engaged in these type of operations and it's vital. And if we don't have someone in the law department that knows about customs, you're probably going to need to get someone like Myron, outside counsel, to assist you. But certainly those two, the general counsel and outside counsel, can confer, and the outside counsel can quantify and codify what you're telling them, that keeping your eye on trade compliance is critically important. My mind, trade compliance has to be discussed in the boardroom, just as SOX and other compliance matters with operations are routinely discussed. It belongs in the boardroom, and that can help you get it there. All right, Ned, if you want to, if you've got a bunch of other questions queued up,
yeah,
let you fire away.
Okay. One of the questions, a very simple one, is what is the biggest obstacle for becoming a direct filer within I guess it's from an organizational perspective?
Yeah, in my opinion, and I've done it 2 times now, and then a whole bunch more times since working with TRG Direct, just really getting your head around the process. It's important to know that it's not an all or nothing operation. So when we were at Target getting ready to tackle 300,000 entries, there was no way we were going to turn that on all in one day. In fact, it took better than a year to completely roll that program out. Direct filing is something that you can roll out at your own leisure. So you turn on one vendor or one country at a time, and until you get that process down, you don't turn on anymore, and you continue having your broker, your current broker, clear other entries, and then you slowly graduate and migrate into this program. The only other obstacle, of course, is getting, in my mind, over the requirement for additional resources. I'll need an army of people. And I'll give you just one quick example. When I was back at Fritz in the brokerage days, and of course this was a manual operation for the most part, but we used to say an entry writer is having a good day if they can do or process about 15 entries in an 8-hour work period. And of course, your productivity is deeply affected by the complexity of those entries. Sometimes if you get a 50-page invoice, you're only going to process 1 entry in a day. So when we got ready to roll it at Target, I said to my team, well, The average standard in the brokerage industry is 15 files a day, so when we're calculating the number of people we're going to need, but we're not going to be doing a lot of things that the brokers did because a lot of our processes were automated and, as I mentioned earlier, pre-populated. And we're not going to be billing anyone. We're not going to be doing a lot of other activities that brokers do. So I said to my team, let's, at least for planning purposes, let's double the standard and plan that every entry writer we have will do 30 to 35 entries a day. Well, I thought my team, I had to scrape them off the ceiling. Oh, that's impossible. There's no way we can do that. You can call them if you'd like. I'd give you the contact information. Target today has people that process more than 100 entries a day. Again, that's highly automated, but in one 8-hour day, you've got one individual, and it goes back to what I said. The more familiar you are with the system, the faster the process goes and the more productivity you incur. So I hope I've answered that.
Yeah, I think that was well spoken. One more question. We have lots, and we'll try to get to each question and get back to the questioner in an email. And I just want to make the comment that this presentation will be available in a PowerPoint format, and it's also being recorded, so it will be available online, and we can advise you of the link if you're interested. So the final question that I have is for a person who obviously is using a customs broker. I assume they want to continue to use it. And the question is, do you recommend that a company initiate quarterly, biannual, or annual broker reviews to ensure compliance?
Absolutely. That's one of the biggest things, the biggest oversights, I believe, is not holding regular business meetings with your broker. And in my view, it's based on your size and your need. If you're a relatively small importer doing a couple of hundred entries a year, once a year should suffice unless there's big issues or problems. If you're a target, we did them quarterly with our brokers. And absolutely, it's also important that you develop the metrics, a scorecard, if you will, so you have things to discuss in those meetings. But that's your opportunity to sit down with them and talk about your business, what plans you have for the future. You might be opening some new stores or some new countries for import that you want to talk through. It's your opportunity to look back and discuss any errors that have occurred in the last period, and your opportunity to hear from them. What's new with customs? What are you hearing on the street? Do you think there'll be a strike on the West Coast? Should I plan contingencies? All kinds of stuff. So absolutely, it's one of the biggest oversights in this industry. It all comes down to good communication. And as you know, it may be an overuse, but if you don't communicate both ways, the broker to the importer and the importer to the broker, you're going to be probably subject to some issues or some problems. It's like I mentioned earlier, the broker has errors that he's not telling you about because he's aware of them and just fixes them for you. No, you need to know about those errors so you can go to the vendor and get it fixed once and for all, and it doesn't perpetuate itself.
Hey, Mike, I think as an adjunct to that, one of the things Ned's trying to pinpoint there is the frequency of those audits. And I think that that's going to be dependent on the size of the company. So,
well, their volume, Greg. And when I was at Fingerhut,
yeah, right.
Again, as I mentioned, it's one of the mind-numbing things that but I felt obligated to do it, and I wanted to know if our broker is earning their keep, so to speak, and earning the fee that I'm paying them to do the entry. So, my days were busy and full of meetings. I'd grab a bunch of entry packets, and I know you shouldn't take your documents out of the building, but I did. I'd grab a bunch of entry packets on my way home at night, and I'd sit in front of the television with a bowl of popcorn, like a school teacher grading papers, and I start auditing entries while I'm watching TV. And I was blown away by the number of errors, of course, you find when you do that. So, yeah.
All right, I think we need to summarize now and let people go. We've gone about an extra 15 minutes here, but we certainly appreciate the attendance today and the interest in this topic. I think what we'll do here is probably roll our sleeves up after this and add this topic and some additional items, since we did get some questions that haven't been answered and some other ideas, to have some further webinars into the future on this. Ned mentioned we will be forwarding out the PowerPoint in a PDF form for you to review, and also have access to this in recorded form. So we appreciate everyone joining us today, and we will look forward to continuing this this topic and this item in future webinars. Thanks again for your attendance.